Welcome to Illuminati Silver's Inner Sanctum, where we tell you the truth about precious metals, banking, economics, and politics. Today is Tuesday, the 27th of November, 2018, and this is the first part of a three-part series entitled The Truth Behind JP Morgan. JP Morgan, now known as JP Morgan Chase & Co., is an American multinational investment bank and financial services company headquartered in New York City. It is the largest bank in the United States and the sixth largest bank in the world by total assets, amounting to just under $2.8 trillion in 2017. Its CEO is Jamie Dimon, and revenues last year were a little over $99.6 billion. And it has 250,000 employees worldwide. The services it offers include investment banking, markets and investor services, treasury services, asset management, and private banking. The company was first formed in 1854 when Junius S. Morgan joined George Peabody Co., which became Peabody Morgan Co., a London-based banking business headed by George Peabody. Junius took control of the firm, changing its name to J.S. Morgan & Co. in 1864 on Peabody's retirement. Since then, a number of acquisitions and mergers occurred, including in 2000 Chase Manhattan, which itself was looking for yet another significant merger to improve its position in investment banking. And JP Morgan Chase & Co. was formed. The result of this is that JP Morgan Chase's history now predates 1854 and in fact originates to 1799, when a company called the Manhattan Company was chartered. The initial result of the merger was for the JP Morgan name to be used for commercial banking and Chase for its greatly expanded retail banking operations. However, in modern banking history, JP Morgan is most renowned for its acquisition of Bear Stearns due to the 2008 economic collapse, allegedly to help out with the world banking crisis. We shall cover more of this in part 2. JP Morgan Chase has, since that acquisition, been embroiled in much controversy, rumor, conjecture, and lawsuits. There were many fines and charges brought against JP Morgan in the early to mid-2000s, but the fines were generally modest. But in 2006, JP Morgan agreed to pay $425 million to settle a lawsuit charging that its securities operation misled investors during the dot-com boom of the 1990s. In May 2010, the FDIC, which is the Federal Deposit Insurance Corporation, announced that Washington Mutual and JP Morgan had agreed to settle claims relating to the latter bank's failure. The agency did not cite the size of the settlement, but it was later reported to be about $6 billion. In June 2010, JP Morgan Securities was fined a record £33.32 million by Britain's Financial Services Authority for failing to protect client funds by segregating them appropriately from firm funds. In 2011, JP Morgan agreed to pay $56 million to settle charges of having violated the Service Members Civil Relief Act. In June 2011, the SEC announced that JP Morgan would pay $153.6 million to settle allegations that in 2007 it misled investors in a complex mortgage securities transaction. The following month, July, the SEC said that JP Morgan Securities would pay $51.2 million to settle charges of fraudulently rigging municipal bond reinvestment transactions in 31 states. This agreement was part of a $228 million settlement the firm reached with a group of federal regulators and state attorney general. In July 2012, JP Morgan agreed to pay $100 million to settle a class action lawsuit charging it with improperly increasing the minimum monthly payments charged to credit card customers. In July 2013, Federal Energy Regulatory Commission announced that JP Morgan Chase would pay $410 million in penalties and disgorgement to ratepayers to settle charges that it manipulated electricity markets in California and the Midwest. In October 2013, the Commodity Future Traders Commission announced that JP Morgan would pay $100 million to settle charges that it violated the Dodd-Frank Act prohibition against manipulative conduct in the trading of certain credit default swaps. In November 2013, JP Morgan agreed to pay $4.5 billion to settle claims by a group of institutional investors that the bank had sold them faulty mortgage-backed securities between 2005 and 2008. In December 2013, JP Morgan was fined $108 million by the European Commission for its role in the illegal manipulation of the LIBOR interest rate index by major US and European banks. There was also a $13 billion settlement JP Morgan reached with the US Justice Department in 2013 to resolve allegations of abuses in the period leading up to the financial crisis. In January 2014, federal prosecutors announced that JP Morgan would pay $1.7 billion to Madoff victims in order to settle civil and criminal charges that it failed to alert authorities about a large number of suspicious transactions made by Madoff while it was his banker. Also, the Office of the Comptroller of the Currency fined JP Morgan $350 million for deficiencies in its anti-money laundering controls. In 2015, it pleaded guilty to a criminal charge of currency market manipulation, but was allowed to continue business as usual. In September 2018, just 2 months ago, it agreed to pay 6 current and former employees $19.5 million in a settlement for racial discrimination. It also settled a separate suit for $55 million last year for discriminating against minority mortgage borrowers. Now, Chase Manhattan, prior to the merger, were also not quite as clean as many believed. It agreed to pay at least $22 million to settle lawsuits asserting that its credit card customers were charged illegitimate late fees. And after the deal was completed, Chase racked up hefty losses primarily related to the bankruptcies of Enron and various telecoms, especially Global Crossing, as well as the debt crisis in Argentina. In 2003, the Securities and Exchange Commission, the SEC, announced that Chase would pay $135 million to settle charges relating to its role in helping Enron manipulate its financial statements. The same year, Chase's securities arm was part of a $1.4 billion settlement by 10 firms with federal, state, and industry regulators concerning alleged conflicts of interest between their research and investment banking activities. Its share was $80 million. In 2005, Chase agreed to pay $2.2 billion to settle a suit brought by Enron investors who claimed the bank participated in the energy trading firm accounting fraud. Also in 2005, Chase agreed to pay $2 billion to settle a suit related to its role in underwriting bonds for a company, WorldCom, at the center of another accounting scandal. These cases and lawsuits have rolled on and on and on. Now, to put this into perspective, some of us worked at the head office of a bank, and it was not unusual for the legal director to have 100 outstanding cases on his desk at any one time. It is not uncommon for organizations of these sizes to have a relatively active legal department. But what does appear unusual is the extent of corrupt practices that JP Morgan and Chase Manhattan have been fined for, together with one or two other major banks, not all, but a number, and yet allowed to continue to practice, and with very few, if any, employees or directors being given a criminal conviction as a result. This has led to the charge that these banks are beyond the law, at least the criminal law, and are too big to fail. Worrying most of all is that these crimes were committed under three very different presidents: Clinton, Bush, and Obama. And the question many ask is, will the Trump presidency be any different? Initial signs are that it will not be, and the removal of Dodd-Frank by President Trump will once again allow the banks to enter into more risky ventures as they did in the early 2000s, and his intent on deregulation, while sometimes beneficial, can only ultimately lead to those with corrupt intent chancing their arm even further. So we have some of the world's largest institutions, and one in particular, wielding great economic might through asset control, income generation, and population employment, while at the same time undertaking numerous corrupt practices, often in contravention of its own rules and regulations as well as the common law, and doing so, receiving easily payable fines and limited repercussions. Naturally, this just leads to public suspicion and distrust. In part 2, which will be published in a few days, we shall look more closely at the Bear Stearns acquisition and the 2008 banking crisis and the part JP Morgan Chase played in it. And in part 3, which will be published next week, we shall look at JP Morgan's alleged manipulation of the silver market and ask whether it is real or a conspiratorial fantasy.
Disclaimer. Illuminati silver owners come from a background of banking, international wealth management, and economics. Having now retired from these worlds, we are not qualified to give investment advice. Therefore, this and other productions must not be deemed to be giving such advice and merely represent the personal views of its owners.